Holsworthy. The question is the bill now be read a second time. I call the member for Newtown.
Thank you, Mr Acting Speaker, and I rise on behalf of the Greens in this place to speak on the Limitation Amendment Child Abuse Bill 2016. The Greens support this bill which seeks to remove the statute of limitations for civil claims for damages related to child sexual abuse. It is encouraging that this bill and the improvement that it will provide to those seeking justice has support across this chamber. I wish to acknowledge the work that my Greens colleague in the other place, David Shoebridge, has been doing for a long time with victims and survivors of child abuse and highlighting the need for reforms. And I believe it was, as everyone has agreed here and acknowledged, a very positive step to see the recommendation come from the Royal Commission into Institutional Responses to Child Sexual Abuse in relation to this bill. The subsequent action that we saw last year in support of this reform that the Greens have long been committed to seeing by the opposition with the introduction of that bill, and now the action from the government in introducing the current bill that we are debating, demonstrating that we are all united in our desire to act in a way that will provide a measure of immediate justice for victims by improving their access to the courts. This bill, as has been outlined, will amend the Limitations Act 1969 to remove any limitation period applying under the Act on the cause of action for damages that relates to the death or personal injury from child abuse. The change operates retrospectively to all historical child abuse claims. This is crucial as we know that the average time for a survivor to disclose sexual abuse is 23 years, meaning the current 3-year time limit for civil claims for compensation is a serious and inevitable obstacle to justice. For victims of child abuse, the 3-year time limit runs from when a victim turns 18 years of age. Victims and survivors of abuse have had enough challenges in their way coping with the effects of the abuse, so wherever possible the law, and especially our limitation to the laws, should not add to the burdens they already suffer and face. Currently, to make a civil claim after the 3 years from when a child victim has turned 18, a person must seek the leave of the court. This limitation, often used by defendants' lawyers to reduce the amount of compensation offered in settlement conferences, is unacceptable. On the 14th of September 2014, the Royal Commission into Child Abuse issued its final report on redress and found that the statute of limitations is an inappropriate and unfair obstacle to victims of child sexual abuse seeking civil redress. Recommendations 85 and 86 of the report recommended the changes that this bill is now proposing, and as such, changes that have been implemented in Victoria with the Limitation of Actions Amendment Child Abuse Act 2015 that came into operation on July 1, 2015 in that state, with one difference to what is being currently proposed in New South Wales, which I will address in a moment. The Royal Commission has found that civil compensation is an important part of the healing process for many survivors of abuse and provides an incentive for institutions to improve their protection of children in their care. For this reason, it is crucial that artificial barriers that prevent victims from accessing justice are removed as soon as possible, and it is what this bill seeks to do. The changes that will be realised as a result of the successful passage of this bill have the support of a wide range of stakeholders, community groups and support organisations across this state and across the country, including the Indigenous Social Justice Association, Bravehearts, the Survivors Network of Those Abused by Priests, Women's Legal Services New South Wales, the Survivors and Mates Support Network and Adults Surviving Child Abuse, as well as, of course, of many of those who support and many who have been victims of and are survivors of, and the family and friends of those people who have been impacted themselves by child abuse. Before I conclude, I wish to foreshadow that there is one amendment to this bill that the Greens will be seeking to make in the other place that will actually seek to bring this legislation in line with the definition of abuse consistent with the recently enacted Victorian legislation that removed the statute of limitations in that state. This amendment relates to the concern we have around the inclusion of the word serious as a qualifier of the physical abuse required to satisfy the definition of child abuse in the new Section 6A. We have concerns that this qualifier would increase legal confusion and challenges, presenting a possible additional obstacle for victims and survivors of child abuse. My Greens colleague David Shoebridge will address the concerns we have about this qualifier and the reasons for the proposed amendment when he moves the amendment in the legislative chamber. I wish to conclude by again expressing the Greens' support for this bill and commend the government, opposition and all in this place for the unified support that there is for this important reform that will improve and aid victims and survivors of child abuse to be able to access justice. It is a significant role that we all have in this place to ensure that we introduce laws that will protect the most vulnerable in our community and ensure that they are treated with dignity, respect and have access to justice. And this bill will make a contribution to that responsibility.